Because of the recent mass shootings, more and more members of Congress, really on both sides of the political aisle, are pushing for some type of gun control. And the one that's gotten a lot of attention, even among Republicans, is red flag laws. Well, I'm speaking with someone today who says that's a bad idea. Professor Robert Natelson, who is a senior fellow in constitutional jurisprudence at the Independent Institute, a former constitutional law professor, and a senior advisor to the Convention of States Project, is joining me right now. We're going to talk about gun control, red flag laws, and many other political issues on this edition of the Florida Roundtable. And Professor Rob, how are you today?
I'm great, and it's really an honor to be with you.
So before we get started talking about red flag laws, how it works here in Florida, and how they want to implement it nationally, I wanted to give you an opportunity to give a little bit of your background and what you currently work on, how you're currently involved in politics today.
Well, I was a law professor for 25 years. I taught constitutional law and a lot of other courses. But I haven't spent my life just as a professor. I had extensive political experience over the years. I was a candidate for governor of the state of Montana. I also have run my own business for many years. And I'm a historian as well as a lawyer, and so a lot of my work has gotten attention among other scholars. It's gotten attention from the courts, including Supreme Court justices that have relied on it a number of times. And my passion and my focus is the U.S. Constitution, the founding, but also how it applies today.
And this past week, we did celebrate Constitution Day, and we're going to talk more about that later on in the show. But right now, gun control is a really big issue across the country because we've had these recent mass shootings. And I understand that you're passionate on this subject, and we've talked about how the Republicans are really pushing for red flag laws, and that's actually something we have here in the state of Florida. What are your thoughts on red flag laws?
Well, first, I think the attack on the Second Amendment is a selective attack. After all, the First Amendment is probably just as responsible for mass shootings. I mean, the mass shootings in many cases are copycat events. Information about them is spread by the press, by other media. And yet no one is talking about restricting the First Amendment, and I think that's correct. The reason they're talking about restricting the Second Amendment is because there's a large constituency in this country that wants to attack gun owners. And you're right that red flag laws, as they're called, is are the type of law probably being most talked about. Now, before I get into the content of them, I want to point out that the term red flag law has a really bad history. And I think that a lot of people who promote the term red flag law didn't know that history before they selected that term. The phrase actually dates to the 19th century when state legislatures and the British Parliament passed laws trying to stop the development of the automobile. You know, the automobile was not a popular invention at the time. You had buggy manufacturers who were threatened by the adoption of the automobile, horse farmers, people who ran stagecoaches and so forth. And so they got to the legislatures and they asked the legislatures, this is in the 1860s and 70s, they asked the legislatures to pass laws squelching this new invention. And one of the most famous requirements was that if anyone had an automobile and wanted to use it on the road, there was a maximum speed limit of only 2 miles an hour in the city, 4 miles an hour in the country. It had to be manned by at least 3 people, one of whom had to walk 60 yards in advance, warning people and carrying a red flag. So the term red flag law became proverbial for a law that was supposedly about safety, but is really deceptively about something else. And I think that is largely the case here. What red flag laws are supposed to be about in the current discussion is preventing people who are dangers to themselves and to others from holding firearms. And it may very well be, in principle, possible to develop a good red flag law. I'm not denying that possibility. However, Mike, what has in fact happened in every state is that the flag laws have been constructed in a way that disregards the basic standards of due process and in many cases represent an assault on several of the different provisions in the Bill of Rights. And so that's one reason why some of us who are skeptics about red flag laws are skeptical about them. There's one other thing too, and I'll end this rather long answer, and that is that I don't understand why we should be talking about a proposal that has no proven record of success. There have been two major studies that I found on red flag laws, and they don't seem to have any effect on crime at all, except that one of the studies found that they may actually increase the amount of rape. So again, I'm not sure why we're even talking about red flag laws and about restricting people's rights in absence of evidence that they actually work.
No, it's interesting. We are talking nationwide about red flag laws, but here in the state of Florida, we did more than talk. We actually passed bills that implemented red flag laws. I understand you actually did a little bit of research on what we have here in the state of Florida. What are your thoughts on how it was implemented, and do you think it will work at all here in Florida?
Well, the United States Constitution says that no person should be deprived of life, liberty, or property without due process of law. It says that in two different places. And the U.S. Supreme Court has interpreted that to mean generally that you can't take somebody's property without giving them a chance to be heard and a hearing on the merits. In very rare cases, you can freeze someone's property. In other words, for example, tell them not to dispose of it for a short time, and an order can be issued to that effect without notice. But there are very, very high standards that the Supreme Court requires before such an order is issued. In the case of Florida, for example, Florida's red flag law is a little bit better than some of the others. For example, in Florida, only the police may petition for an order taking away someone's guns. In Colorado, where I'm sitting right now, somebody who was the gun owner's lover years ago can go into court and in a revenge case claim that the owner is mentally unstable and get his guns away, and the gun owner doesn't even have a chance to respond. In Florida, the jilted lover can't do that, but the police can, and the police tend to be more careful, but it's still true that the guns can be taken away. A person can be prevented from having guns without even having a chance to respond. The Supreme Court has said when it is necessary to freeze property, and not necessarily take away property, but even to just put a hold on it without notice, then the standards are generally that the person seeking the order has to demonstrate by clear and convincing evidence that there is an imminent or immediate danger to the plaintiff or to other people. And generally speaking, the plaintiff has to post a bond so that the defendant is compensated if the order is not a proper one. And generally speaking, there has to be a very, very fast hearing. In Florida and in most states, there's no requirement of a showing of immediate irreparable injury. In Florida, the standard, and this is very common, the standard is merely a significant danger of causing personal injury to himself or herself or others. No time frame. I mean, it could be, well in the future. And in requesting the order without notifying the gun owner, the person bringing the suit only has to prove reasonable cause in Florida. That means a fair preponderance of the evidence, the lowest possible burden of proof. And in Florida, like most red flag states, there's no requirement that the person seeking the order post a bond, even if that person could well afford to post a bond, a bond being an insurance policy to protect the defendant in case the order is improperly issued. Also, when the hearing occurs, it can happen by telephone. So that means that the gun owner doesn't have the ability to meet his accuser face to face in violation of the spirit of the Sixth Amendment that requires that. These laws have been described as a frontal attack on the Bill of Rights because if you go through the Bill of Rights, they seem to attack the Second Amendment, the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, as well as the 14th Amendment, which protects people against state action that violates due process.
I'm speaking with Professor Robert Natelson right now. He's a senior fellow at the Independence Institute and a former constitutional law professor. You know, a lot of times when I hear defense of red flag laws from, say, Florida Senator Rick Scott, they say that, like the laws in Florida, they put enough due process in where it's still okay. It's not taking away your constitutional rights. Do you agree with him at all on that?
No, I think he's flatly wrong about that. First, a lot of the discussion of the Florida law has been basically along the lines of, well, only the police can seek the order, and the police require two different lawyers to review the case in advance, and the police are very careful. And I don't deny that at all. But that's not what due process requires. The due process clause isn't about the prosecutors being really careful before they bring a case. The due process clause is about giving people the ability to be heard in court. And in those very rare cases where somebody does not have the right to be heard, the U.S. Supreme Court says that can be true only for a few days, and that there's a very high burden of proof that the prosecutors have to go through. Reasonable cause doesn't do it. What is required is showing by clear and convincing evidence that the owner whose property you want to freeze or take is somebody who could do irreparable harm, like immediately, like right away, not sometime in the future. So there's some effort in the Florida law to impose some safeguards, but I don't think those safeguards meet due process standards. And frankly, the laws in a number of other states are even worse.
And we're going to continue this conversation in a moment. I'm speaking with Professor Robert Natelson. We're talking about gun control and specifically red flag laws and whether they're even constitutional. We're also going to talk about the Constitution and the importance of that founding document because this past week we celebrated Constitution Day. Red flag laws. That's what has been pushed by not only Democrats, but many Republicans in terms of gun control. This all in an effort to stop these mass shootings, which seem to be increasing. At least they're getting a lot more attention than they used to. I'm speaking with Professor Robert Natelson on this subject. He's a senior fellow at the Independence Institute and a former constitutional law professor. He's also a legal expert on many different issues and a resource for many people when it comes to the Constitution and the rule of law. And Professor Rob, I appreciate you coming on the show today.
It's a kick, I'll tell you. It's fun.
All right. And so in the last segment, we were talking about red flag laws and how it wants to be. Well, you were specifically going over some of what's been implemented in the state of Florida. And you are actually against red flag laws nationwide because you feel like it abridges people's constitutional rights and there's not enough due process involved. How exactly would this work on a federal level? Because doesn't this have to be implemented by the states specifically? Yes.
Under our federal system, red flag laws are classically an area that is reserved to the states, that the federal government has no jurisdiction over. Now, of course, in recent years, that hasn't stopped the federal government. The federal government doesn't pay much attention to the Constitution's limits on its powers anymore. So Senator Lindsey Graham of South Carolina has proposed a federal grant program which would give money to the states to pass red flag laws that he believes are more consistent with due process. Why we need another federal program, I'm not sure, given the size of the federal debt, but that's what he's proposed. And from listening to him, I think he has a better understanding of the requirements of due process than, let's say, the Florida legislators when they adopted the Florida red flag laws, and certainly a much better understanding than the House of Representatives recently evinced in its proposed red flag legislation. The problem with this, and I mentioned that I'm not just a constitutional wonk, I'm also experienced in politics. What in fact happens when measures like this are proposed is that they tend to get changed in ways that are most damaging to due process. And I'll give you a good example. In Colorado, when they were considering red flag law here, there was no provision for any deadline for returning somebody's guns after the law expired. There was no provision for a deadline for returning someone's concealed carry permit. And by the way, in the Florida legislation, they don't have deadlines for that either. That's another problem I didn't mention. So what happened when the Colorado bill was being negotiated is some folks said, look, what we need deadlines so that if the order is over or if the order is rejected, then somebody can get his guns back. And so the sponsors of the bill said, okay, we'll put that in. Well, they put it in supposedly, but several weeks later, I was reading the Colorado legislation, and what they did is they left big gaping holes in the legislation that ensured in many cases people would never get their guns back, or at least would not get their guns back on any kind of real time limit. What tends to happen in the legislative process is you've got people standing up and they'll say, this law isn't strong enough, it's not going to prevent enough crime, and they'll water down the due process provisions again and again. So as I mentioned to you, Mike, it is theoretically possible to come up with, I think, a constitutional red flag law. But one is very unlikely to come out of our state legislatures as fully constitutional in the current environment.
So are there any gun control measures out there that you actually support?
Yeah, I mean, I think the Supreme Court identified them correctly in its most famous case on the question. For example, the mentally ill historically have not been permitted to have guns. You should have an adjudication first that somebody's actually mentally ill, with an opportunity for the person accused of being mentally ill to cross-examine and to have counsel and so forth. But if the person really is mentally ill or otherwise legally incompetent, if the person is a minor, if the person is a felon, another category mentioned by the Supreme Court, I don't think that person should have firearms. Also, I think there are certain kinds of firearms that are definitely outside the protection of the Second Amendment. Naval ordnance, cannons, for example, are not the kind of firearms, certainly nuclear weapons are not the kind of firearms that are mentioned in the Second Amendment, which refers to basically handguns or rifles, that is to say, guns that can be borne. So there is a fair scope here for government to legislate. One of the questions that comes up is that we've got a mass shooting problem in this country, and what can we do to address it? And I don't have a conclusive answer on that because I'm not a criminologist, but I would suggest two things. Number one, whatever solution you adopt should be one that's constitutional. I mean, that's should be kind of a duh thing,
Well, it should be a duh thing for more than just gun control, but in today's country, it doesn't seem that way.
Yeah, and the other thing is that when you're looking for a solution, you want to say, look, we've got this problem that's rising, this increase in shootings that's rising. What is it that has changed that could cause this? I mean, if something is the same as it was back when there were no shootings, then that's a pretty good indication that that thing that hasn't changed isn't really connected to the shootings. And in fact, gun legislation is in that category. We don't have noticeably more or less gun control than we had before the shooting started. So that's not it. There's some other change in society that is going on that's causing the shootings. And so what our policymakers need to do is they need to look at that. And there have been a lot of candidates suggested. I mean, some people have talked about the decline of religion, the the breakdown in community ties, the increase in government dependency and government programs, problems in the school system and the education system, problems in greater problems than in the past in identifying people with mental problems. So there are plenty of candidates out there for things that have changed and therefore might be contributing to this increase in mass shootings, but gun control just isn't one of them. I mean, that's something that really hasn't changed. I mean, we didn't have a whole lot of gun control 40 years ago, and we didn't have very many mass shootings either.
I'm speaking with Professor Robert Natelson right now. We're talking about gun control. Also, the Constitution. And as I mentioned earlier, this past week we celebrated Constitution Day. And it's obvious, just talking to you right now, Professor Rob, that the Constitution is incredibly important to you. And you believe it's still relevant today, as relevant as it ever has been. But it seems like there are some in this country right now who kind of believe it's outdated and either needs to be completely revised or changed. Why is the Constitution important to you?
Because the rules of the game can determine whether you get outcomes, results that are good or bad. And here's a great example I use sometimes. You can take 10 people and you can have them play softball. That is to say, the sport is according to certain rules, the rules that apply to softball. Or I should say 20 people, because I think in softball it's 10 people on a side as opposed to 9 in baseball. So everybody can have a good time under those rules. You can take those same 20 people and change the game so that the rules of the game are the rules of Russian roulette. And there you're going to have tragic outcomes. People are going to die. As our founders recognized, in fact, as the ancient Greeks and Romans recognized, the rules that you have for a society, the rules that people have to play by, can result in really good results or bad results. And in America, our Constitution created a society that was phenomenally successful. Not perfect, but phenomenally successful, especially during the period when the Constitution was still in effect. That is to say, the first 140 years of our existence, before there tended to be breakdowns in restraints on government power. It was the most successful, greatest amount of progress of any society that ever existed on the planet. And that was achieved under the U.S. Constitution. The U.S. Constitution established rules that allowed people the freedom they needed and the rule of law to produce what they produced. So it's hugely important. It remains hugely important. There are parts of the Constitution that have broken down, notably the limits on federal power. But much of it still remains intact and is still producing good outcomes. Now, there are some folks out there who really want a government that's all powerful.
And we'll continue that conversation in just a moment. I'm speaking with Professor Robert Natelson. I'm Michael Yaffee, and I've been speaking with Professor Robert Natelson. We were talking about gun control and red flag laws and why he feels like most of the red flag laws that are being proposed are unconstitutional. And then speaking of the Constitution, this past week we did celebrate Constitution Day, and I asked him why the Constitution is important to him, and he gave some good reasons on why it's still relevant. But there are a lot of people in today's country, it seems like right now, who feel like the Constitution is outdated and not relevant, and some even feel like it was based on racist principles. So I wanted to get his take on that. Professor Rob, thanks again for coming on the show. What is your take? You were talking about this a little bit at the end of the last segment, but how do you defend the Constitution against those who attack it?
Well, let me tell you where the attacks are coming from. One reason our society was so successful under the Constitution is that the Constitution limits government power. It's not a system like that in some countries where the government can do whatever it wants. There are, however, and always have been people in our country who do want the government to be able to do anything. Take a look, for example, at the tenets of the Green New Deal. Just go online, and you can see that the proposals in the Green New Deal are for federal politicians and regulators to be able to do almost anything they want to you. Well, that's clearly unconstitutional, and that means that advocates of those programs will defend their programs by attacking the Constitution. Famously, there is the claim by Alexandria Ocasio-Cortez that the Constitution or the Electoral College arose out of slavery or that it was adopted by slaveholders. The problem with attacks like that is that historically they're not true. And just to remind you, in addition to teaching constitutional law at the law school level, I'm also a constitutional historian, and so I've gotten into some of the history here. Let's take, for example, the claim that the Constitution was adopted by slaveholders. The Constitution was adopted by conventions in each of the 13 states and also in Vermont, which was the first state to join after the original 13. And those conventions were popularly elected by the general population. There were over 900 delegates in those conventions. The people who voted for the delegates, who then voted for the Constitution, were overwhelmingly not slaveholders. In fact, a very small fraction of them were slaveholders. And of the convention delegates who adopted the Constitution, relatively few of those were slaveholders. Now, the claim that the Constitution was created by slaveholders comes by focusing on the convention that actually wrote the Constitution in 1787 in Philadelphia. That was not the group that adopted it; they merely wrote it. And there were slaveholders among that number, but there were also important delegates who were not slaveholders. Furthermore, if you take the position that, well, the Constitution is bad because slaveholders supported it, you also have to consider the fact that a lot of slaveholders opposed it. George Mason of Virginia is a good example of a slaveholder who opposed the Constitution. So you can cite slavery on either side, but the fact is that slavery had a very small role in the adoption of the U.S. Constitution. There is one part of the Constitution that opponents often point to. It no longer exists. It was taken out 150 years ago. But at the time the document was written, there was a provision in there that said that in counting for purposes of the House of Representatives or for purposes of taxes, 5 slaves would be counted as 3 freemen. And a lot of people will say, well, it was a concession to slavery. That was an unholy deal with slavery. Well, you can also, because of the way it's structured, see it actually as a punishment for slavery. But it was a recognition of certain economic realities at the time, as I've documented on my website.
And one thing that is in the Constitution, it allows for a convention of states to propose amendments. And while this has never happened, this is something you actually support. Am I right on that?
Yes. The Constitution, as everybody who has read it or studied it knows, is a document full of checks and balances. So, for example, the president can veto laws, and the Supreme Court has jurisdiction. This is not explicitly mentioned, but it was understood by the founders. The Supreme Court has jurisdiction to determine if a law is constitutional. The Senate can check the president in the governance of treaties and so forth. One of the most important checks that was put in the Constitution was a provision that says that 2/3 of the state legislatures can at any time demand a meeting called a convention to propose constitutional amendments for popular consideration. And that was designed mostly as a way to check the federal government when it got out of control. One reason we have such an omnipotent and dysfunctional federal government today, in other words, in lay language, one reason it isn't working is because that particular check and balance hasn't been used. And in part, that's because there's a lot of information surrounding it. But I think there probably will be a convention in the next few years, and that important check in the Constitution will be revived.
And the convention will, of course, eventually propose amendments. Any specific amendments that you believe would add to the Constitution?
Oh, I've got a list. I sometimes playfully say that my favorite amendment is one that would abolish daylight savings time. But that's probably not going to be on the convention agenda.
Yeah, maybe. You never know. People are passionate about that, believe it or not.
the American people support term limits, both for members of Congress and for other officials like Supreme Court justices, by huge margins. But Congress has refused to propose a term limit amendment. The convention could propose a term limit amendment. I think that's going to be very high on the list. Certainly an amendment to require the federal government, most years anyway, to run a balanced budget. I mean, I think there's general recognition that we cannot continue to pile up debt the way we are and survive as a society. And even if we could, it would be immoral because it's throwing our obligations on the shoulders of our children and grandchildren. So there's got to be some kind of restraint on how much money the federal government can spend. A restraint like that actually was part of the original Constitution, but the Supreme Court gutted it, essentially rendered it inoperative in decisions issued in 1936 and 37. I think that some kind of amendment limiting the power of unelected bureaucrats in our system, well, the Constitution explicitly says all legislative power herein granted shall be in a Congress of the United States, not in administrative agencies. And while some delegation to administrative agencies is acceptable and has always existed, it's run absolutely wild in recent years.
And Professor Rob, we have just less than a minute now, but I wanted to give you an opportunity before we go to tell people how they can see some of your work. You write for the Epoch Times and some other publications, I believe?
I write twice a month for the Epoch Times. Also, I have a book out called The Original Constitution, What It Actually Said and Meant. You can get it at Barnes & Noble or Amazon. That tells you in lay language what the original Constitution stood for, and it's an honest, objective treatment. The original Constitution, what it actually said and meant. And also, I'm at the Independence Institute. If you go to independenceinstitute.org and click on the Constitution tab, you can find almost all of my writings on the Constitution there.
Professor Rob Natelson joining me on the show today. It's really been a great conversation, and I'll have to bring you back on again sometime.
I'd like that very much. Thank you, Michael.